Welcome to episode 5 of my podcast, David versus Goliath, Adventures of a Pro Se Litigant. David versus Goliath is myself versus IBM. I'm engaged in a civil suit regarding retiree benefit in the area of healthcare, and I'm representing myself, so that phrase for that is pro se litigant, and that's got a lot of interesting aspects to it. It's been a couple of weeks since I did episode 4, and really what's come up is the IBM has submitted their motion to dismiss, and I needed some time to respond to that, and we'll talk about that in this session. I like to go through my standard disclaimers. I'm not a legal professional, so nothing in here should be construed as legal advice or counsel. I'm not a medical or medical insurance professional, so I'm not offering any medical insurance or Medicare coverage advice. There is a current civil action between myself and IBM, so anything that I say that's a wrongdoing of IBM is alleged. They're in my filed complaint. IBM has not admitted to these allegations. In fact, they've responded with a motion to dismiss, and the outcome is not yet resolved. The wrongdoing I'm alleging is age discrimination, and there's another discrimination in there as well. I think these videos are of interest to IBM retirees who are in the same situation as myself and have the same challenges presented by IBM. The whole topic of Medicare and Medicare supplemental and Medicare Advantage is a complex topic that's quite controversial right now. So I think there's interest in that. Any civil action done with self-representation has not got a lot of, there's no YouTube how-to videos. In fact, if you do Google the whole idea, generally you're told don't get a lawyer. Big mistake. Likelihood of being successful very low. That's a general advice. So this is to help someone who still wants to go down that path, as I was determined to do, and there's good reason why I did. And anyone that likes to follow a good oppressed versus oppressor story, that's me, David versus Goliath. These are my two main tips for anyone deciding to do pro se. Do it one step at a time. My big step recently has been focusing on this motion to dismiss. And in doing that, I've found a couple more team members that could help me out. So the timeline to date, although this started for me already in the first and second quarters of 2023 when I realized that I'd been denied a benefit that I used to get in the prior 2 years, I did nothing. IBM changed. And I decided to file suit. It started with a discrimination charge at the EEOC. I covered that in, I think, episode 2. And the result of that was they gave me a right to sue letter to sue within 90 days, which I did. I filed the complaint towards the end of November. And there was supposedly 21 days for IBM to respond. They missed it. They asked for another 30 days. They responded January 10th with a motion to dismiss. And I filed my response January the 25th. This recording is now around the end of January, so that's been in for a few days. Okay, I'm going to switch back to the camera for a moment. I have a couple of things to show. So this whole business of this rules, and where are these rules? Oops, I just lost my screen. Hold on one sec. There I am. One of the documents that I got when I went down to the court, for the process is this one here. There we are. Federal Rules of Civil Procedure. This is countrywide, so all the federal courts use this. Northern District of California, Southern District of New York, Eastern District of North Carolina. It's about 100 pages. And about 100 rules. We'll look at Rule 12 in a minute because that's the one that the main one that IBM responded under. That's not the only rules, by the way. Here's another 100 rules. These are specific to Eastern District Federal Court. Some of those rules are placeholders, but it is 100 pages, and it does go up to 80, 90, 100 in there. Basically, you got to be cognizant of what all these are. Again, don't try and memorize it. Just as it comes up, look it up. And then your own judge that's assigned may have some specific procedures that he likes people to follow. And so you got to read these and stick by those. So we're going to jump here in a moment right to Rule 12. So you can see what I read. and what I concluded. Okay. So this is out of that federal document. In the index, so we're in this Title III section, Rule 12, defenses and objections, when and how presented, motion for judgment on the pleadings, consolidated motions, waiving defenses, pretrial hearing. Okay, so it sounds like a pretty big rule, and remember I said that was, somehow these lawyers knew that 12b6, you're going to get a 12b6, so let's go right to that, Rule 12. Okay, 12b, how to present defenses. 6, failure to state a claim upon which relief can be granted. I read that and it didn't really sink in, but basically what that means is if your claim is just BS. And if in the view of the defendant it's BS. So, we hear about, different stories like that. Again, someone files even a criminal charge. It's like, well, I wasn't there, or never heard of this person, or whatever. Because really, if what I'm going to do for a moment is I'm going to take us back to the timeline, and this was kind of an eye-opener to me because I thought I put so much effort into that original document. All right, back when I did that document in November, I agonized over that a lot. And, I tried to keep it concise, 10 net paragraphs. Maybe it was too brief, but I was very proud of it. But then I just realized hardly anybody's read that. So unless somebody goes in and downloads the docket, nobody at the court has read it. There's been no need because there's been no real action on their part aside from kind of administrative action. Now, the IBM defense has read it and they responded, and in their response I can tell they read and responded to any ID I presented, any paragraph. They did quite a powerful response. But the court hasn't read it. And so now I thought I did all that effort and, nobody at the court's read it. And, I started to think about what's going to happen next. And so now that I've submitted a response, then they're going to have to, somebody eventually at the court, I think in sequence what will probably happen is the judge, the judge has a lot of busy cases. Mine's just a petty little, $20,000 suit against a, $90 to $100 billion company or whatever IBM is currently. Kind of like, how much time, are they really want to spend on this? And probably a dismissal would be attractive just to get rid of this, annoying little problem. So I had to really think about how they're going to read my response. So the lack of a legitimate claim means, again, they said there's nothing clear in here that IBM sees as an offense. Or an actionable offense against which a court could do something. It's kind of like no valid charge. It's almost like in a criminal case, you don't have a witness or you don't have a body, habeas corpus. It's something kind of extreme like that, saying there is nothing really here. And I have to admit that when I read their response, it was pretty convincing. So, given that if I had not known what my original complaint was, and I read the response, I go, yeah, this guy probably didn't really know what he's doing. And there was another interesting claim in their motion. They actually had 4 main areas in their motion to dismiss. One was the standard 12b6. There's nothing really here. And then there was an interesting one. IBM is not really a party to this. And this got into an interesting sort of sidebar of who's the real entity that's at fault or who's the real entity that I should be suing. And there was almost like a recommendation should be suing the plan, capital T, capital P. I thought that's just a document, but it is actually at the end of the summary plan document. I'm not going to quote that, but it does say, hey, this is the legal entity that should receive things. And I looked at some other, motions that had been filed and dismissed. There was one in Connecticut that I saw, And there they'd actually identified, 4 or 5 parties in it. So there's a bunch of agents that help IBM execute this part of the benefit plan. There's Fidelity Insurance, Optum Bank, United Healthcare, and the plan. So I saw one where like all 4 of those and IBM were listed. I thought, how would I serve all those? Because I'm supposed to serve the suit to all of them. Anyways, and I also decided the other interesting thing that happened was I didn't know how much time I had, and so one thing that I did was just started writing my response immediately. And I was trying to engage with the lawyer for I decided I was going to spring for some paid advice because I thought this is serious. If I lose this, it's game over, right? The whole suit's done. I got to get past this hurdle to keep going. Otherwise, it's out, refile or appeal, maybe, if you even have a chance to do that. Or now I'm thinking, hey, maybe I just have to refile and put the plan on there as one of the defendants. Maybe that would work. But I thought I should get maybe some more legal advice. And just coincidentally at this time, I was finally reaching some lawyers that I guess had the appropriate background, which I needed this combined background of employment skill and ERISA skill. That's the statute of the benefits. And was willing to talk, and actually, did give me some, free advice for a while, and I thought, let's go again. And so anyways, I did pay for them to review the defendant's motion and just talk to me about it. So one question I asked was, reads pretty well, like, were you convinced reading it? And how would the judge feel reading it? And they basically advised that it's pretty good. We think you're going to lose, George. So that's okay. I mean, I've had different odds of 10%, less than 10%. And then in the review of the study, like almost 60% end in dismissal. So I know I'm not at blackjack odds. I'm kind of more long shot. And but it was good feedback. And then the other question I asked was, well, that response was chock full of citations. Hey, in the case of, and then how that works, you read the motion and say, well, in the case of this versus that, let's say it's IBM versus someone else, or there was Walmart versus someone. And they cite the case number, maybe the date, and you don't really know what it was about, but they'll pick out a couple of very key words in quotes that obviously have come up in the summary out of that, and those words are now used against me. What was one? There was no discriminatory animus. Animus was another one where I had to look. Oh yeah, here's another resource which I'm going to recommend, the pro se litigant. This is known to every law student and every PI, policeman, and I've checked that out with some others. This version was fat. I did, and I got a simpler version, so it wasn't as bad. Basic law, but basically it's Black's Law Dictionary. It's well known, so I can look up some of these. What is invidious intent? I don't know. Why are you using these Latin words on me? And what exactly is a summary judgment? Stuff like that. So, and I found something very interesting when I was in there. So it was pretty much of a letdown. And then also, I'm just thinking now, I had a little note here, talk about emotional moments. This was an emotional down moment, right? When they came back and said, and I'd already written a full response, but the problem was I didn't like my response. I read it and I thought, all I'm doing is, just arguing with them paragraph by paragraph. And that's not going to work, because if I'm the judge reading that, I'm going to go, this guy's, doesn't know what he's talking about. And, what do you look like? You look like a disgruntled employee, and that's a typical pushback, is this guy doesn't have a legitimate case. He's just, ticked off about, something that happened. We changed the plan. It's within our right. And that was all through their motion. The guy's really just mad that they changed the plan, but it's fully within our right to do that. And it is within their right. They can even withdraw this benefit completely and make it go away. They have a lot of upset people then, so they have a lot of strong rights protecting them, but I don't think they have the right to discriminate. So that's where I have to bring it back to that. So the other thing that I thought those 33 citations, and I talked to someone else and I said, boy, I didn't even respond to anything. Oh, you got to respond to them all. All? I can't even read them. How am I going to respond to them? So number one is, I guess I got to rewrite my response. And I got to do something about those 33. Oh, I did ask that lawyer that I hired to review. I said, if you'd written the motion that way, would you be proud of it? Yeah, that was pretty good. About those 33 citations, don't you think that was a little excessive? No. That's pretty common. We do something like that. I mean, they must have just cut and paste all these things. Hey, let's get one of these, stick it in here. But I mean, it looks pretty powerful, right? So I thought, this I knew was one of my big weaknesses in being a pro se. Two big weaknesses I knew right up front after I thought about it, after I filled out that cover sheet, was one, I don't really know how litigation works. It looks like a chess game. You take a move, hit a timer, the other guy has to do something. They take a move, hit a timer, it's something like that, and I don't know what all the moves are. Well, I do sort of. They're in those rules, but I don't know, the normal. When can I castle? If it's like chess, can I castle now? Right? Can I go for a throat? Can I do a mate move now, or is it impolite? So they've gone right for checkmate, right in their first move, right, end the game, right. They got me surrounded. And then the second one was like I wanted to do case research. Are there other cases, of IBM discrimination? I couldn't find any of that. All that is Google of stuff that was in the press. So there they got 33 cases. So I agonized for a day, and then I thought, you know what? I'm going to send the opposing counsel an email and just say, guys, I'm pro se. You put in 33. Oh, I didn't mention that. I said you put in a lot of citations, and how do you expect me to respond to that? I said, you got to help me. I'm making it your problem. I said, one thing I could do, they have an office here in Raleigh, North Carolina. I said, I could come to your office. I'd be happy to sit there and type away at your terminal, and you can have someone, look over my shoulder, one of your staff, make sure I don't do anything bad. Oh, I know what. They can do the typing, and I watch and direct, ask them to do this or that. Or what do you suggest? And that's how I sent the email. And they came back, oh, George, we'd be happy to send you the case summaries. Great. So in a couple of days, or over the next 2-3 days, I got the 33 case summaries, which is an abbreviation. It comes out of one of the law library databases. I don't know if they use Lexis or Westlaw. I think they might use Lexis at the council. And I looked through all the cases. So I thought, okay, now I'm starting to form my response. And I actually thought a lot about, how to write the response, how to make it look, visually interesting, because it's pretty boring looking black and white, kind of like, reading those rules. And I did put quite a bit of effort into rewriting it. Will I be successful? I guess we won't know. And I'll be back with an update when that happens. But anyways, if you can all keep voting for me in your hearts and minds, then we'll see if I can make it to the next hurdle. Thank you very much for listening to me today.